So our first presenter is David Bloom from UW-Libraries. How you know you need to disclose.
So today I'm going to be talking about the kind of preamble, the run up to invention disclosure a bit, because that is a question. Like, when exactly is it time to disclose an invention? As mentioned, my name is Dave Bloom. I'm a science and engineering librarian housed at Steenbock Library. I'm also the Patent and Trademark Resource Center rep for campus. And what that means is that I'm a designated rep for a program that extends throughout the nation. There are about 90 of us, about 90 libraries, some public, some academic libraries. And we basically work with folks either on campus or in a community or both, and talk them through the basics of patenting something. Give them a little bit of information just so they know what they're getting into, and teach them the specifics of searching and how they can devise some good search strategies in going forward. Because searching is a really, really important part of this whole process. And so you might be asking, why libraries? Why do libraries come into play into this? And I think it has something to do with the fact that patents are not just protection. Patents are often kind of framed in that way, where we think about them as, I'm going to protect my intellectual property with this thing, but they're actually an exchange. So this is a WIPO definition from the World Intellectual Property Organization. A patent is an exclusive right granted for an invention, which is a product or process that provides, in general, a new way of doing something or offers a new technical solution to a problem. To get a patent, and this is the part that I really like to emphasize, technical information about the invention must be disclosed to the public in a patent application. So that means this stuff is out there. If you want to learn about how someone patented something, why it's patented, how the device works, that information is all arranged and out for you to discover. So what we're going to do today a little bit is go into how you can use that information to your benefit and use some of the criteria that the US Patent and Trademark Office uses in figuring out whether something is new, is an actual invention, and not just something that wouldn't be patentable or protectable by other means of intellectual property. And I should kind of offer that as a caveat too, that I'm going to be talking about patents. I'm going to be using their framework to talk about how something is protectable as intellectual property. But of course, some of you are probably working on things that maybe aren't patent protectable. Maybe they're protectable through some other means like copyright, which is very often the case with things like apps and software. So I'm going to be using the framework primarily because the patents are out there, they're easily discoverable, and the criteria is very clear in terms of what actually is protected and why it's protected. So first of all, in the United States, we protect three main types of things under patents. We protect utility patents, plant patents, and design patents. These things differ depending on the area of the world in which you function. In the US, we've decided to put design patents under that kind of patent rubric. In other places in the world, designs are actually protected in other ways. Utility patents are by far the most common patents that you'll encounter. They're the things that most of you are probably working toward. They protect processes, machines, manufactured articles, compositions of matter, and improvements to any of those things. A lot of the patents that you see from day to day, the things that you experience, the products that are out there that are patented, are going to fall under that broad category of utility patents. Plant patents are less common. They protect asexually reproducing plants, excluding tubers. For some reason, potatoes don't get the same deal. There are other ways to protect other kinds of plants under utility patents, but under plant patents, we protect things like asexually reproducing types of apples, types of plants, roses, things like that is typically what you'd see when you look through plant patents. Design patents protect ornamental designs only. Anything that's out there that has a function and an ornamental design, and they're protected by patents, chances are that they're going to be protected by both a utility patent and a design patent, protecting the non-functioning aspects of something. So for instance, if you're talking about a cell phone, all the functionality, a lot of the procedures and stuff that go into creating it, a lot of that's going to be protected under utility patents. The apps, the software, that's probably going to be a combination of utility patents and maybe copyright. But the casing, kind of the non-functional parts of it that make it aesthetically pleasing, those are going to be protected under design patents. Primarily, we're going to be talking about utility patents because that's more or less what you're mostly going to be interested in today and probably what you'll run into. So we have these four main types of intellectual property protection in the United States. I'm not going to focus on every single one of these, but I just want to draw your attention to the way that registration works, because in some cases here, registration is completely optional. So copyright has optional federal registration. In terms of trademarks, you can actually optionally trademark something on a state level or federally. but it's not like an absolute requirement in some ways. Trade secrets are not registered anywhere. Trade secrets protect things like the KFC secret recipe, Coca-Cola recipe, things that it wouldn't make any sense to patent because, as mentioned, you have to fully disclose how things work, and the patent protection will only work for a certain amount of time. By protecting it through a trade secret, by which a company just kind of keeps the secrets close to its chest, those secrets don't get out there, they're protected indefinitely, and there's no chance of people just kind of reading through patent documents and figuring out how you made your thing. So patents do actually have to go through a very substantial process, more substantial than pretty much any of these others. There is an application process that you have to file through the U.S. Patent and Trademark Office in the United States. If you want to protect it internationally, you've got to file through multiple patent offices, depending on where you want to register. So there's the USPTO here, there's the European Patent Office, protects in Europe, Japanese Patent Office. So some of them are territory-based, some are country-based, but you have to do it in each one of those places to kind of get that protection. Each one of these patent applications that goes through a substantial review process. So the examiners at the USPTO really get their hands full. They look through a lot of documents, and what they're looking for is something I'll talk about in a second called prior art. And so they go through this entire process. It can take a while, and then ultimately, if a patent issues, you have the option to keep it for about 20 years if you pay your fees. A lot of folks don't actually maintain their patents for 20 years. Sometimes technology just kind of isn't worth protecting for that full range. I mentioned prior art. So prior art is basically all the stuff that's out there that can anticipate your invention. This can include anything from inventions disclosed in U.S. and foreign patents and the patent applications that went towards them, inventions that were disclosed in publications. So we're talking about scholarly articles, trade journal articles, even in some cases like Amazon, if they're listing a product that's for sale, that can actually count as disclosure too. So you have to be really careful about what you disclose in terms of putting inventions out there without any kind of protection on them. This includes inventions that were disclosed by you. So if you're in the process of writing a scholarly article or something, and there's something that's being discussed in there that may actually be considered prior art by the USPTO, you're definitely going to want to get in touch with WARF and go through the disclosure process, because they're going to have some tips on how you can protect that. Make sure that you're not actually invalidating your own chances of getting something. Because if prior art exists out there, that could be a threat to you getting something patented. Because one of the things, or a number of the things they're going to be looking for have to do with the originality, and they're going to be looking at all that prior art to determine whether your invention is actually going to be novel, non-obvious, or useful. So that's what we're going to talk about next. There are three main criteria that the USPTO looks at in addition to kind of how you're disclosing, how you're actually explaining your invention in your patent application. And those three main things are usefulness, non-obviousness, and novelty. So I'm going to start with usefulness. This is usually where the bar is set relatively low. When the examiner's office gets this, they just kind of review the patent to make sure that it works, essentially. So they're going to make sure that it's a specific utility. So you're not going to say it's a treatment for diseases. It would have to be a treatment for something more specific than that, a treatment for leukemia. It's got to actually be proven to function in kind of a non-broad specific way. It has to have substantial utility. So it's got to work now. It's not pending additional research. It's not, I'm still kind of gathering data on this. And it also can't be for throwaway use. So you wouldn't want to patent transgenic mice with a designated use as snake food, because that would be kind of wasteful and it just doesn't make a whole lot of sense. And then it also has to have a credible utility. So what I've put up here, the example is an attempt at getting time travel patented, a certain type of time travel. And so what happened is that they couldn't reduce this to practice. They couldn't figure out a way to actually make it look like this would work in a real world scenario. So like the theory behind it might have been okay, but they couldn't prove to the USPTO that it had credible utility. There was no practice to it. The second criteria, this is where the bar is set a little bit higher. This is novelty. So is there a single example of prior art, anything, like I said, in the patent literature, out there just kind of swimming through scholarly journals, that completely anticipates the entire invention as you're trying to patent it? If it passes that, then is there a single example of prior art that completely anticipates one of the claims that's been made in the patent? And I'll talk about claims in just a minute, but those are basically enumerated parts that indicate what's novel about this invention, what's completely new, what's non-obvious about this invention. So it's possible that you'll get it to the USPTO and discover that maybe some of your claims are perfectly novel, others maybe aren't. And usually there's some negotiation with the USPTO examiners in terms of figuring out things that need to be taken out. And the final one is non-obviousness, and this is one that a lot of folks get caught up on first time through in terms of trying to get something patented, because it seems like a real easy thing to get past, but it actually comes down a lot to the writing of the patent and how things are explained. So an invention can be deemed obvious if a person with ordinary skill in the subject, discipline, or field could conclude that the invention just combines prior art elements using known methods for predictable results. You're taking two things that are out there existing in the prior art, mashing them together, and they do exactly what you'd expect them to do. So it's the idea of, I have patented a very specially folding ladder, and it's like 15 feet tall, and someone comes along and does the exact same thing but makes it about a foot taller. That's a pretty obvious combination of elements that's probably going to preclude you being able to patent that invention. You also can't just substitute a known element or a technique for predictable results. And then also, it can't just be a minor variation on known work in one field used in a predictable way in that field or in another field. So a lot of folks get hung up on this, and a lot of it has to do with how you explain how your thing is not just an obvious next step in a pattern of previous inventions. So if none of you have taken a look, if you haven't had an opportunity to take a look, this is what a patent looks like kind of in its native form. So this is what a printed PDF patent would look like. There are patent databases that make things a little bit more clear, but baseline is this is what the granted patent will actually look like. You'll notice the title of this. It's a method for making a seamless plastic motion discomfort receptacle. Any guesses as to what that is? Colloquial terms are fine here. I heard barf bag. Yes, it's a method for making a barf bag. And the reason I like to use this example is because it's a really common object. It's pretty simple. You wouldn't think you'd still be able to patent something having to do with barf bags, but you can. This is actually a patent that's still alive, still functioning for its 20 years. But also the reason I like to point it out is because of the terminology. So searching for patents is not always necessarily easy because the words barf and bag don't necessarily appear anywhere in the documentation. So you have to be really strategic in how you think about your keywords when you're running searches in the patent databases. I also use this to kind of show just basically the setup of the front page of a patent. So you're going to see the inventor, the assignee. Those are two separate things. Inventor is always going to be an individual's name or a set of individuals' names for the life of the patent, even beyond the life of the patent. Those individuals are going to be reflected on this form, and it will be reflected accurately in the databases as well. The assignee, those rights can change. That's whoever actually owns the rights. So in this case, if you're reporting something to WRF and WRF ends up being the ones to patent it, they're going to be the ones listed as the assignee. That's where organizations can actually be listed. But you and your team perhaps are always going to be listed as the inventors. There are a bunch of other things that I could probably go into detail on here, but I'm going to skip over them just for the sake of time, so we have time to get to the next few presenters. But some other major parts of the patent documentation. So we've got diagrams. There are always going to be illustrations. There are going to be sometimes, in some cases, photos, whatever it takes to visually get across the point of the patent. So these can be very valuable. I know particularly I've worked with folks who have been looking up patents for certain types of chemistry applications. Looking through the drawing sheets is sometimes the easiest way to find things if you're looking through chemistry-oriented patents. Then there's also going to be the description. And so this is kind of the narrative. This is like the full deal about what exactly this invention does, the context for it. Here is where you're going to be kind of making some of your arguments for why this isn't just an obvious riff on something that's previously existing. But what it doesn't do is specifically lay out what's protected. So you're going to be able to put out a whole bunch of information here, explain everything about it that you think is necessary to get across the points of your invention, including how it was made. But it's not actually what is protected. What's protected is in a very small part of this description section called the claims. And these occur just at the end. They usually start with a preamble, like what is claimed is, and then there are a numerical list of what the actual protected elements of this patent are. It's a little hard to track down in the PDFs of these documents, so you actually have to look for it a little bit. Most of the databases that you run searches in, though, split these out, make it a little easier to read. They indicate a little bit more easily what kind of refers back to similar related claims. So the claims are kind of an interrelated set of embedded sort of claims within themselves. So there are a number of databases you can run your searches in, but I'd like to kind of lay out some basic good practices before searching databases, because this can save you a lot of time if you really think about how you're doing this. So you want to think about what does it do. You don't want to put in barf bag, right? Because like I mentioned, colloquialisms aren't easily found in patent databases. You have to think very much about structure, purpose, things like that. So you want to think about what's novel about your approach to solving the problem. Are you interested in patenting the process or the product? Those two things can appear very differently sometimes in the documentation. You want to think about what it's made of, how it's used, what are some synonyms for it, and other words that describe its nature. And you want to think about, in some cases, known organizations. So you may know that there are companies already making products like the one that you're designing. So what you can do is use that knowledge and piggyback on it and kind of run similar searches based off what you know about those organizations. Sometimes that happens with inventors too. Maybe you know researchers at other institutions who are working on similar products. Use that knowledge, like follow up on it and see where it goes. Beyond keyword searching. So those are good places to start. They're often where people tend to end. And I would highly advise you not ending there, even before you maybe report your invention to WARF. Maybe do a little extra searching using some of these techniques. So maybe you found at least one relevant patent or a patent application. You can find other patent literature listed for the patent assignees and owners and inventors on that invention. So follow up on those. Most of the databases have really good hypertext, interlinked kinds of things. You can follow up just using the linked assignees and inventors and kind of go and track down the rest of the inventions they may have patented or applied for patents for. You can review all the prior art listed in the patents and the non-patent references as well. So sometimes non-patent references are listed within those patents. So they may actually refer out to like the Amazon ad for something, like the entry, where you'll be able to track it back that way. You can also review patents that list this patent or patent application as prior art in the reference. So you've got one patent, you'll actually be able to track that forward using most of the databases, and you definitely should do that because chances are they're going to be relevant to your work too. If the one patent you found is going to be relevant, the stuff that came after it is going to be relevant as well. This is the big trick, though. This is the one that everyone doesn't know about unless they actually get some specialized training. Every patent that goes through the USPTO and the other international patent offices gets assigned at least one classification code. And the one system that we're mostly using these days is called CPC. It's Cooperative Patent Classification. And what this does is it assigns categories to all the stuff that comes through the offices. So usually multiple categories, and they're agreed upon. So you don't have to rely on your own terminology so much because inventors use different terms to talk about their inventions, even if they're very similar to other inventors' inventions. So what it allows them to do is kind of create these nested categories. So in this case, A61J1900, you can track it down that way. It's under human necessities, the broad category, under medical or veterinary science and hygiene, certain types of containers, and then specifically devices for receiving spittle, e.g. spittoons for dentists. And this is where barf bags end up. So where can you run these searches? There are a few different options. The official ones aren't necessarily always the best bets, which is why I actually have the US Patent and Trademark Office site listed last here. One site that I really like lately, they've been doing a lot of advancing lately, is a site called lens.org. All of these are completely accessible, completely free. We don't even have subscriptions to them on campus. They're just out there on the web. And they've got access to international patents in most cases and patent applications. So the lens is great. It combines a lot of features, a lot of filters. If you're used to doing any scholarly article searching, the filters that they offer are going to be very familiar to you. And they allow you to do a lot of following up using those CPC codes I mentioned. So it's a really good way to do combined keyword and CPC searching. Google Patents is very, very forgiving. It's a really good place to get started if you're just getting the feel of how to search for patents, but it doesn't allow you to do a whole lot of exploration and filtering. So it's going to be a really good entry point, but you're not going to want to end up there because chances are you're going to get too many results to even analyze. So good place to start. You'd want to use that in combination with something else. And one good option would be Espasnet, which is the European Patent Office patent website. They do a very, very good job with their classification searches. They don't do a very good job with keyword searching, but if you use that in combination with Google Patents, which does keyword searching pretty well, you can get pretty good results by then following up on the classification codes that Google has by using Espasnet. And that does include US patents, despite it being the European Patent Office. It's US patents, patents throughout the world, including European and elsewhere. Finally, US Patent and Trademark Office. They do have great definitive information behind the patents. If you learn to use it well, you can actually dig up all kinds of stuff. You can even dig up letters between the applicants and their lawyers and the examiners at the USPTO and find like specific exchanges between these people and get like a lot of really good details on the patents. The problem is the way in requires you to get to know two different databases, one for applications, one for patents, and they're limited to just US patents. So it's not a really good place for prior art searching in a lot of ways. Like if you found some prior art that looks particularly relevant, good place to follow it up. But I would never recommend that anyone start their searches here just because it's a little too limiting, and it's actually kind of a beast to learn. It's not the most forgiving database. So I'm going to end here. I'm just going to direct you to a few more patent resources. I maintain a research guide for the libraries. A lot of sites are linked here. Some databases to search, but also kind of organizations, things that you can look at in terms of getting your items patented. Maybe BORF turns out to not be interested, and maybe you need some other kind of support. We've got organizations that may be able to help you with that. And then finally, I also do have the Introduction to Intellectual Property microcourse that we've recently designed. And I encourage you to take a look at it. It's going to be followed very shortly by another microcourse that's dedicated specifically to patents. And I hope that'll be useful to people. So I'm going to turn it over to Beth. And she will follow up on the invention disclosure process proper.